Hi, my name's Nia Jameson. I'm a solicitor at Silk Family Law, and this vlog is following a number of inquiries that we've had in the current circumstances and lockdown in relation to child arrangements orders. So where you have a formal order in place determining the arrangements between you and your co-parent that you have separated from, so where a child has two separate homes. We're all very confident, I think, now with the government's guidance on staying at home and the very few reasons that we're permitted to leave home at the moment to get our essential food and our exercise and for medical requirements. The government went on to clarify that the children of separated parents are also permitted to move between those homes. And for us as family lawyers, that led to a number of concerns about the safety of that movement. Following this, we were issued with further guidance from the President of the Family Division, and I've written a blog detailing that a little more, but just to summarise that guidance for you, it's to do with the movement of children under the age of 18 between their parents' properties, and although that is absolutely permitted, the President has indicated that it should only take place where it is safe for those arrangements to continue. It confirms that parents can agree to vary a child arrangements order in line with what they believe to be safe, that it is sensible to document that agreed variation. So in writing, by text, by email, however you normally communicate with your co-parent. Further to this, there is obviously the issue of one parent believing that it is not safe and the other not agreeing with this. So essentially a unilateral variation of a child arrangements order. The President confirms that a parent can utilise their parental responsibility to unilaterally change a child arrangements order in line with something that they believe to be safe, having full regard to the government guidance as at that time. Obviously it is better if matters can be agreed, but some parents are obviously having different views on what is safe for the children at this time. It is usually at this point that we would suggest that the advice of a specialist family solicitor is required, because if you, in line with your parental responsibility, want to change that order, you are in breach of that order, and therefore you must have proper reasoning and have full regard to the children's best interests in making that decision. My blog, the details of which are below, also goes into some tips on co-parenting during lockdown, as it's obviously very different to normal, and particularly where arrangements have got to change in terms of keeping the children fully involved, but where there are perhaps disagreements to limit their involvement in those sorts of discussions. So hopefully you'll find that helpful.